The 5-year regulation allows authorities to claim your residence, and many elderly people do not realize this until it is far too late to take action. If you are 65 or older, if you possess your house, if you have any nest egg at all, you must comprehend precisely how this policy functions, because the individuals who are supposed to guide you have a very powerful incentive to remain silent. There is one particular instrument that can halt the whole cycle before it ever starts, but many legacy lawyers will not mention it unless you request it by title. I will reveal what that form is labeled before this clip is finished. The policy itself is titled the Medicaid 5-year lookback. But the label is deceptive. It is not truly about reviewing history. It is about penalizing you for actions you took when you had no clue you were making any mistakes. Here is how it operates. If you ever require long-term infirmary residence care, and the typical stay in this land now costs over $18,000 per year, you will almost certainly exhaust your funds. Consequently, you will have to request Medicaid to handle the invoice. But before Medicaid covers a single cent, a state social worker will examine every bank report, every land title, and every donation you have provided for the past 60 months, every single move, every check to a grandchild, every vehicle you handed over, every coin you shifted. Then they compute a sanction. The sanction is not a fine. It is something harsher. The state gathers the total value you shifted during those 60 months, divides it by what they term the regional penalty factor, which in most areas falls between $10,000 and $12,000, and the total is the number of months you are barred from Medicaid benefits. During those months, you must fund the care facility yourself at over $9,000 per month, even though the whole reason you sought Medicaid is that you do not possess $9,000 per month. This is the snare. You donated the money. Therefore, you cannot pay. But because you donated the money, the state will not pay either. So, who funds the care? The care center does not care. They will litigate. And the first holding they will target is your house. Most folks assume the policy only snags large gifts. That is false. The look back snags everything. A $400 holiday gift to your granddaughter counts. Funding for your son's ceremony counts. Assisting a grandchild with school costs counts. Canceling a debt to a relative counts. Trading your car to your nephew for $1 counts. Even charitable gifts over a certain limit can count based on the state. There is no birthday pardon. There is no holiday pardon. There is no I did not realize pardon. The federal yearly gift tax limit, which clears throat, currently sits at $19,000 per person, has nothing to do with this. That is an IRS policy. Medicaid is a totally distinct entity with its own mandates. And Medicaid does not care what the IRS permits. A gift that is perfectly lawful under federal tax statutes can still spark a full Medicaid sanction. Most retirees do not grasp this variation. Therefore, they assume their gifts are secure. They are not. Now here is where it becomes tougher, and this is the portion that ruins unions from beyond the dirt. If you are wed and your partner enters a care home, you might imagine the law shields the healthy spouse who remains home. There is a shield. It is titled the Community Spouse Resource Allowance, and in 2026, it sits at $157,920. That is the maximum volume of counted holdings the at-home spouse is permitted to keep. Everything above that figure must be utilized before Medicaid will cover 1 cent. $157,000 sounds like plenty until you see what it actually must fund. Property taxes, home upkeep, Medicare costs, food, fuel, drugs, crises for the remainder of the healthy spouse's life, which could be 20 years, which calculates to roughly $657 per month. That is the budget the state predicts you to survive on while your spouse is in a center that is billing over $9,000 per month for the same duration. But the house, surely the house is secure. The house is the one asset they cannot seize. That is what nearly every senior in America trusts, and it is false. The house is excluded while you are living and inhabiting it. Therefore, Medicaid will not compel you to sell it before you qualify. But the second the Medicaid user passes away, a system titled the Medicaid Estate Recovery Program triggers. Federal statutes require every state to strive to reclaim the cost of care from the estate of any Medicaid user who was over 55 at the time benefits were issued. The recovery goal is the house. The state submits a lien against the estate. The successors are told they must either clear the debt in full, often hundreds of thousands of dollars, or sell the home and hand over the cash. The average estate recovery demand in this land now tops $74,000. In some states, it is over $200,000, and it is not voluntary. It is not negotiable. The federal government mandates the state to pursue the house. Therefore, the house your parents pledged would go to the grandchildren ends up going to the state of wherever they happen to reside. And in 29 states, including Pennsylvania, North Carolina, New Jersey, Connecticut, and Georgia, there is an even older statute on the books titled filial responsibility. These statutes say that grown children can be held legally liable for the unpaid care home debts of their parents. For decades, these statutes sat dormant. But starting in 2012, after a Pennsylvania court ruled that a care home could fetch $93,000 from a grown son for his mother's care, the barriers broke. Therefore, the snare is not just that the state grabs your house. The snare is that the care home, after the state ends its recovery, can pivot and sue your children for whatever remains. I will share a real case. A widow in Ohio, age 78, moved $45,000 to her daughter over a 4-year span. Birthday checks, holiday gifts, some aid with a vehicle fix. Nothing she viewed as odd. She entered a care home in month 47 of those 4 years. The state split her $45,000 by the Ohio penalty factor of $7,463 per month and barred her from Medicaid for 6 months. The care home charged her $9,200 per month for those 6 months. Total debt $55,200. She did not have it. The home placed a lien against her house. She passed away 8 months later. The state then submitted an estate recovery demand for an additional $140,000 in care expenses. Her daughter got a notice stating that the home she was raised in was being sold by legal mandate. There is a tactic that some lawyers use to ease the impact when there is no time left. They title it the half a loaf. The concept is that if you or your spouse already requires care, you gift away half of your remaining holdings and use the other half to fund care during the penalty span that the gift triggers. It preserves something. It is better than losing everything, but it necessitates exact timing. It necessitates a skilled lawyer, and it must be finished before the Medicaid filing is made, not after. Once you apply, the tactic is dead. The seniors who lose everything are almost never the ones who prepare. They're the ones who were never told preparation was an option. They sat in a clinic room, signed a power of attorney, and started sending checks to the care home with no clue that with one call to the right type of counsel 2 years sooner, they could have shielded the house, the funds, and the legacy. Now, I told you at the beginning that there is one form most legacy lawyers will not mention unless you ask for it. Here is what it is titled. It is titled a Medicaid Asset Protection Trust. In 5 specific states, including Florida, Texas, Michigan, West Virginia, and Vermont, there is also something titled a ladybird deed, which fulfills part of the same task for the home. Specifically, a Medicaid Asset Protection Trust is a permanent trust. You shift your house, your funds, and your stocks into the trust. You no longer formally own them. The trust does, but you can still occupy the house. You can still obtain the profit from the stocks. You just cannot pull the assets back out after the trust has been in place for 5 years. Those assets are no longer seen by Medicaid. The lookback cannot find them. The estate recovery system cannot find them. The house is shielded. The funds are shielded. Everything inside the trust goes directly to your heirs without entering probate, without entering estate recovery, and without being touched by the state. The reason most lawyers do not mention this is basic. A Medicaid Asset Protection Trust costs between $4,000 and $12,000 to build correctly. A basic will cost $200. The senior walks in wanting a will. The lawyer sells them a will. And the talk about long-term care never occurs. Therefore, you must walk in already knowing the right term. You must say the phrase Medicaid Asset Protection Trust out loud. And you must ask if you qualify, and you must do it at least 60 months before any care is required, because the 5-year timer does not begin until the trust is funded. Here is what to do this week. First, collect every bank record from the last 60 months and find any move over $500 to a family member. Make a log. You need to know your risk before you speak to anyone. Second, Find a lawyer who is expert in elder law specifically. The credential is titled CELA, which represents Certified Elder Law Attorney. A general legacy lawyer is not sufficient. You need someone whose whole career is centered on Medicaid preparation. Third, ask that lawyer by title about a Medicaid asset protection trust. And if you reside in Florida, Texas, Michigan, West Virginia, or Vermont, also ask about a ladybird deed for the home. Fourth, get the trust funded right away because every day you stall is a day added to the back end of your 5-year timer. Fifth, tell every grown child in your family to see this exact same data because the policy does not just touch you. It touches everything you intended to leave behind. The 5-year timer starts the day the trust is funded, not the day you pick to plan, not the day you call the lawyer, the day the assets actually move. Therefore, the most costly day in your life is the day after you should have begun.